number 14, matter of Madison County Industrial Development Agency versus the State of New York Authority's Budget Office. Counsel?
Thank you. May it please the court, my name is Charles Malcolm. I'm counsel for the appellants Madison County IDA and the Madison Grant Facilitation Corporation. I would like to request 2 minutes for rebuttal.
Of course.
Thank you. General Municipal Law 858, subparagraph 17, provides the express power to IDAs to do all things necessary or convenient to carry out its purposes and exercise the other express powers given in that section of the statute. Despite what the ABO argues, this is not carte blanche to do whatever the IDA wants to do, and it does not swallow the other 16 enumerated powers.
I'm having a little trouble understanding why that issue is here in the following sense. I read what the ABO did or said as there's some uncertainty about, based on the Attorney General's opinion, about whether you can do this or not. And given the uncertainty and given another issue they identified, we want you to report separately. Why isn't that within their discretion? And why is it that the underlying issue that you think, I guess, the underlying issue of whether that you can or can't form a subsidiary is really here?
Okay. Well, the ABO had a policy. It's at record page 70, which basically said that subsidiaries can file consolidated reports. This is obviously more cost-effective for the IDA to be able to file consolidated reports.
That's not specifically subsidiaries of IDAs. That's specifically subsidiaries of all types of public authorities.
Correct. Subsidiaries in general. Right.
Yeah.
So if you have a subsidiary and you meet the criteria that are spelled out in the ABO's policy, you're able to file consolidated reports. The ABO in this case denied the IDA and the GFC's request to file consolidated reports on the basis that the AG's opinion saying that we don't have the legal right to form a subsidiary. That was based upon an error of law. Based on the ABO's own policy, the GFC and the IDA had the right to file consolidated reports.
That's my question, though. Is it an error of law for the ABO to say there's now some doubt about the ability to form a subsidiary, and therefore we want to proceed cautiously? Is that a question of law?
When an administrative agency doesn't follow their own policies, that's improper, that's arbitrary, and the arbitrary decision was based on an error of law. The sole reason in the record that was provided as to why the IDA and the GFC did not have the ability to file consolidated reports was on the basis that the IDA didn't have the power in the first place. And we submit that that's not correct based on the plain meaning of 858 subparagraph 17. So if you look at the argument is, well, all these horrible things could happen, you're outside of the 16 other enumerated powers when you're doing this, I would submit that this is a limited power. It's got to be limited by necessary or convenient to the exercise of another express power consistent with the IDA's purposes. So here the record was undisputed that the IDA and the GFC met all three of those requirements. It was admittedly convenient. The ABO's never argued otherwise. The third department conceded that it was convenient. It was to carry out an economic development purpose to confer a grant on private business to spur job creation in the C&D recycling sphere. And it was for the exercise of another express power, the power to accept and use grants. So it's your position that one of the things I'm having some trouble here with is trying to figure out the distinction between an affiliate and a subsidiary and what rules apply to each. But if we agree with you that IDAs have the authority to form subsidiaries, are you saying that the ABO then would have no authority, and this is sort of a follow-up on Judge Wilson's question, to require that subsidiary to separately report? The ABO could provide for reporting through the PARA system as it deems appropriate, provided it's consistent with the statutory language of the Public Authorities Law. The ABO went and issued policy guidance under that provision saying that a subsidiary meeting specific criteria controlled by the parent entity can file consolidated reporting. Now, if the ABO wanted to revisit that and choose different requirements or not allow subsidiaries to file consolidated reporting with their parents, that certainly would be another question as to whether or not they were acting within their authority.
What if it's an affiliate? What if it's called an affiliate under the Public Authorities Law, not a subsidiary? In that case, can the ABO require separate reporting?
They do.
They do.
They require separate reporting for affiliates. Now,
Okay,
the strange thing, and where I think the ABO gets confused on all this, is an affiliate and a subsidiary is a type of affiliate. An affiliate is broader. It encompasses the parent and the subsidiary within that definition. If you look at the not-for-profit corporation law.
Why I'm confused as to your position that the ABO couldn't require, under its authority to require an affiliate to file separately, why couldn't it require Madison Grant to file separately?
We haven't specifically taken the provision what they can and can't do with respect to reporting. We've taken the position, here's what they did.
Okay.
They said in their policy that you can have consolidated filing with parents and subsidiaries. They, in their policy at Record 70, set out the specific criteria as to how you meet that definition. We've met it. They don't dispute that, and they denied us our ability to file consolidated reports, which we think was error. But to the point of the affiliates versus the subsidiaries, the ABO, in the record at 106, in the affidavit that they submitted below, said, well, yeah, it's common for IDAs to have affiliates and to use these for their purposes. Well, where's that power in 1 through 16 of 858? And the answer is it's in 17, the same for subsidiaries. They have not articulated why the creation and use of an affiliate is somehow so beyond the scope of 858.17. And so we would submit that if you take a look at Public Authorities Law Section 2, which talks about what the definition of a local
Can I
authority
ask,
is.
since putting aside for a moment this particular argument you made about there's no power other than in 17 for affiliates as well as subsidiaries, why is it more convenient to have the subsidiary than the affiliate?
Well, I would say that an affiliate and a subsidiary are related, and a subsidiary is a type of affiliate. I would think an affiliate could be convenient, but a subsidiary is as well. And it may be more so in the fact that the parent can control the subsidiary in a different manner. So,
Wasn't there a public policy basis, though, for the ABO's initial receipt of the power to do this, to audit, basically, the activities of these subsidiaries or affiliates? And that was that the local IDAs, the state had determined, were in many instances not reaching their contractual goals. In other words, like a number of hires, things like that, their employment goals, their economic development goals. So they set up a process to require that there be an auditing, and that you can't evade the auditing and evade whether or not you meet your local requirements by trying to draw in a distinction here between subsidiaries and affiliates. Isn't that really what's at the core here of their policy?
you see, in the brief to this court, the ABO talked a whole lot about transparency and the purposes for the recording.
Well, I'm not
But
even
they-
so much concerned about transparency. In other words, the great wider world knowing about everything that's going on. I'm talking about whether or not we gave a contract to somebody and they gave them reduced tax breaks, and they said they'd hire 42 people and they hired 3. And we want to audit that to make sure that they did that. And we don't want to say that you can set up a subsidiary that would prevent us from doing that kind of work. Isn't that what's really underlying this?
So I think we're confusing the auditing the IDAs in general with
No, I
the-
understand. I'm not talking about auditing their costs or anything like that. I'm talking
Okay.
about the success of the contract itself.
What we're arguing for here, consolidated reporting, that does not, nothing different is submitted to Paris.
So the ABO could meet its goals then, is what you're saying?
Absolutely.
Under the consolidated review approach.
Absolutely. And as a matter of fact, below, we argued that there is no difference. We pointed out, here's what the system is, here's what the ABO said they were initially concerned about, that, there might be some things that wouldn't be caught up in a consolidated report. We refuted that. They abandoned that argument at every level. And they've tried at the last minute here to say, well, we're losing something by having consolidated reporting, but they conceded that at the third department below in their briefs.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon. May it please the court. Rob Goldfarb appearing for the respondents. The authority's budget office rationally required the IDA and the Local Development Corporation to file separate disclosure reports.
Well,
Judge Wilson,
Yeah, how about the issue about whether they operated under an error of law and whether the IDAs can form subsidiaries? Would you start with explaining, first of all, telling us if you agree that an IDA can form an affiliate but not a subsidiary, and if so, where the former power comes from and what's the difference?
yes, Your Honor. Our position, and as laid out in our brief, is that the legislature did not grant the IDA authority, express or implied, to create a subsidiary.
But do they have the authority to create an affiliate?
The IDA's enabling statute, General Municipal Law 858, doesn't authorize an IDA to create an affiliate either. The authority to create this local development corporation is not conferred by the IDA enabling statute. It derives from not-for-profit corporation law 1411, which allows any individual over 18 to create one of these local development corporations. This local development corporation was caused to come into existence by the IDA, but it was incorporated by an individual over 18. ABO has not taken the position that this entity was not validly created, just that it is a separate local authority required to file separate reports under the Act. And Judge Wilson, it would be enough that there is uncertainty about whether this entity can create subsidiaries to make this a rational determination. For the reasons we state in our brief, we don't think there is uncertainty.
Does the ABO have the power to determine whether an IDA can create a subsidiary?
The ABO only...
If I'm an IDA, can I apply to the ABO for a determination that I can or cannot create a subsidiary?
No, Your Honor, but as opposing counsel points out, ABO does have a policy of permitting consolidated reports for parents and subsidiaries that act as divisions of the parent. When ABO told this authority that it was the Local Development Corporation was an affiliate under Public Authorities Law Section 2.2, they responded saying, well, can they be treated as a subsidiary? At that point, issue was joined on that question. ABO quite reasonably sought an opinion from the Attorney General and reasonably relied on that opinion, and I think that's enough to make this a rational determination.
Can I ask a follow-up on that one point? Let's assume your opinion is wrong, that they do have the authority, just for purposes of this discussion. They do have the authority to create a subsidiary. Would that necessarily mean that there's no rational basis for their action?
No, Your Honor, for the reasons I've stated. It's enough that there is, well, to accept that there is no authority. No, because Public Authorities Law, Section 2.2, specifically denominates this local development corporation to be a quote-unquote affiliate of the IDA, not a subsidiary. Section 2.2 defines a local authority to include 5 separate types of entities. They're broken out. Section 2.2
Those are a lot of sections, but if you could, and I'm getting a little confused by them, but if you are wrong on the subsidiary point, and they do have the authority to create a subsidiary, does that necessarily make their decision, the ABO's decision in this case, irrational or based on an error of law?
No, Your Honor, it doesn't. Because,
and why without sections is that true?
Well, I think it's important that the Public Authorities Law specifically denominates this local development corporation to be a subsidiary. If you look at to be an affiliate. I'm sorry, Your Honor. If you look at the definition of a local authority, there is no mention of subsidiaries in there. If you look at the definition of a state authority, it defines it to include subsidiaries of such public authority. The definition of a local authority says an IDA is a local authority and an affiliate of an IDA is a local authority. Both are required to file separate reports. I'd also add that the determination is consistent with the LDC Certificate of Incorporation, which by its terms contemplates separate reports. It says, it's at page 112 of the record. It says the entity is subject to the Public Authorities Accountability Act, will be required to undergo independent audits and submit its annual budget to ABO.
But
And
now,
another,
if the agency, if the ABO said to them, clear, and let's assume again, not specifically here, but let's say they did, they say to this company, we're doing this and we're making you file separately because we have this opinion that says you can't drop a subsidiary, and therefore our view is you have to file separately. And now, let's say your advice that they couldn't drop the subsidiary was wrong. So wouldn't we have to send it back if they're saying to the party, you can't do this because of the legal advice we got from the AG? Wouldn't, even if they can do it under these other provisions, would the proper remedy be for us to send it back to the ABO to say, do you want to do this, even assuming that they can do this subsidiary?
no, Your Honor, because that's not the only reason that they gave. And they gave other rational bases for requiring separate reports. If you look at the letters that constitute the determination in this matter, it's also rational to require separate reports here because these local development corporations actually have to report different content than an IDA. That's specifically the recipients and the amounts and the purposes of the local development corporation's grants.
And that's in the record, these other reasons as to why they were doing this?
That's not only in the record, it's in the determinations at issue. That would be at pages...
They may have provided these other reasons, right? But if their own practice, if their own guidance says that subsidiaries are entitled to file consolidated reports, and we find that they were entitled to form a subsidiary, then do those other bases, do those other rationales matter?
I think those other rationales matter a great deal here
Well, how can
because...
they matter if their own policy is to allow subsidiaries to file separately?
Because their policy is to allow subsidiaries to file with parents where the legislature has granted explicit authority to create a subsidiary
Is that what it says?
in the enabling statute.
Is that exactly what it says in their?
That is what it says now, and that's what it meant at the time, Your Honor. It simply has to mean that the entity has legislative authority to create a subsidiary.
We say they do. That's my point. If we say they have implicit authority, okay, or however, if we say they have implicit authority, then don't those other rationales?
No, I still think the other bases for the determination here would provide a rational basis. But let me explain to you why the AG has a correct opinion here. An entity only has the powers expressly conferred or those required by necessary implication. The IDA's enabling statute does not expressly confer authority to create a subsidiary. And we have a great deal of other evidence in other enabling statutes, they're in my brief, that where the legislature intends to confer this, it does so expressly.
Isn't that where they give the subsidiaries special powers or rights, and so they, in order to describe what they're allowed to do, which they otherwise wouldn't be allowed to do, then they have to expressly, say that there's a right to form them because they're not your typical subsidiary, which, as I understand, doesn't have all the rights, for example, of an IDA necessarily.
Well, you're correct, Your Honor, that the legislature does also enact provisions describing what the subsidiary can do, limiting its powers, describing what its attributes would be.
What about Public Authorities Law 2827A, which provides that no state authority shall hereafter have the power to organize any subsidiary corporation unless the legislature has enacted blah, blah, blah. Doesn't that imply that up until then, the state did have the power to do that? And also imply, since it doesn't mention local authorities, that the local authorities have that power as well?
No, Your Honor.
Why
First
not?
of all, a legislatively created entity's powers have to come from its enabling statute. This court has never inferred powers for a creature of statute.
But the legislature gave it the power to do anything necessary or convenient to perform its other expressly enumerated powers.
In all of the enabling statutes that I discuss in my brief, Your Honor, where the legislature has given an entity explicit authority to create various subsidiaries, they also include the necessary or
Counsel,
convenient
let
clause.
me ask you, so what understanding should we import to the word convenience in this provision?
The necessary or convenient clause, by its terms, only authorizes necessary or convenient acts that are incidental to the exercise of an express power. That's what it says. And here, that's the power of the IDA itself to accept grants. Creating a new entity to accept the grant is not merely incidental to that power, because the IDA is no longer accepting the grant. This court has never viewed a necessary or convenient clause as permitting a legislatively created entity to do anything that it alone deems convenient, and for good reason, because this would permit the entity to do anything it wants and would just swallow up the rule that a creature of statute lacks powers.
Why can't it be convenient to protect themselves from liability? I mean, that's basically what they've done, right? Or tried to do.
Well, the desire of the IDA to insulate itself from all liability from accepting grants does not render it essential for it to create a subsidiary.
It doesn't have to be essential, it has to be convenient.
Convenient.
Well, Your Honor, in expressly authorizing an IDA to accept grants of public money, there's no indication that the legislature
isn't your
intended an
argument, though,
IDA could
Counselor,
insulate itself.
Isn't your argument really that if the necessary and convenient clause is as broad as counsel argues, then there is no reason for express clauses, because the express clauses and express grants of authority would be unnecessary. Everything would be subsumed into either a necessary or a convenient power that will be granted by the mere application of that phrase.
Yes, Your Honor, you've articulated better than myself. And I think this court's decision in the Abeal construction case really makes the point. It held the New York City Construction Authority lacked power under a necessary or convenient clause to make, in that case, a quasi-judicial determination under a contract.
And the core of that basically is that the necessary and convenient phrase must be read with the express powers that are granted, not in substitute for the express powers that are granted.
That has always been the rule, and that is the express language of the necessary and convenient clause we're dealing with here. It talks about necessary or convenient to carry out the purposes and exercise the powers expressly given in this title. And the power in this title is in subdivision 11, which is for the IDA to accept grants and use them for its corporate purposes. And creating a new entity to accept the grant is not incidental to that power. One more point before I sit down. I just wanted to point out how at its base, it's the IDA's position here that's really unreasonable and contradictory. The IDA wants separate liability, but at the same time, it's objecting to separate reporting. But if another entity is going to incur the liability, it's all the more reasonable for that entity to file separate reports disclosing its activities and showing that it has the ability to meet those obligations. So it's this insistence on separate liability.
We find that they have the power to create a subsidiary. Does that deprive the ABO of requiring them to file separately?
No, Your Honor. For the reasons I've stated, there are other rational bases for these. The fact that the LDC is required to report different content that would not be captured on the IDA's
What difference does it make
report.
to you then whether they have the subsidiary or not?
I'm sorry, Your Honor?
What difference does it make to you if they have the subsidiary or not, if the point of all this is to have them file separate reporting?
Well, they asked for this entity to be treated as a subsidiary. Therefore, we considered that question. We sought an opinion from the Attorney General, but for all the reasons I've stated, they do not have that authority, and that's another rational basis for this determination.
Thank you, Counsel.
Thank you.
Counsel?
I'd like to go to Judge Fahey's question about the express power to create a subsidiary and how that swallows the rule. If you look at the language of the other public authorities that have that express language, it's much broader.
You mean the necessary and convenient
No,
language?
no, the subsidiary specific express power. It's much broader than what the necessary or convenient clause would allow with respect to creation of subsidiaries. So those statutes have similar language, all reading something along the lines of, you can create a subsidiary for, quote, all purposes. So if it's consistent with the purpose generally, powers, duties, functions, or activities. In order for an IDA to do it and to fit under 858.17, it has to be necessary or convenient, okay, to the exercise of another specific express power in 858, consistent with the IDA's purposes. So it's more limited than what, and the fact that these other authorities have separate and different authority to create a subsidiary doesn't somehow remove the power of an IDA. The language is clear. You don't go to other statutes and go to the other interpretive tools if the language is clear, and I would submit that necessary or convenient is certainly clear. I would also point out that it would be...
So where is the rule, where's the line going to be drawn for the rule? What would not be convenient?
Well, it would have to be necessary or convenient to the exercise of an express power consistent with an IDA's purposes. So you have to tie it back to another express power. It would have to be convenient to that. So wherever the line is...
He says that if you're trying to hook this to 11 for the grant,
right,
that it's supposed to be about the purposes of that corporation itself, not another entity. Why isn't he right about that?
I'm not sure I follow.
Okay,
the
well,
question.
11 talks about accepting a gift, a grant, et cetera, and so forth,
Correct.
for any of its corporate purposes. I understood his argument to be that means it's only for the IDA. It's not for another entity that you create for purposes of insulating yourself.
But when you're using a subsidiary under the necessary or convenient clause, you are accepting a grant consistent with the IDA's corporate purposes of economic development. And the fact that you want to appropriately structure a transaction consistent with...
The corporate purpose being?
The corporate purpose being an IDA's statutory purpose under 858 with respect to economic development. So there's nothing about the creation of a subsidiary to facilitate the grant, but it's not just the grant funding. Like, for example...
Again, how does that not end up being you can do anything?
Because it has to be tied to an express power, it has to be necessary or convenient, and it has to be consistent with an IDA's purposes. That's not everything. And wherever the line is, creating an entity for the purpose of properly structuring a transaction is nowhere near it. And I would suggest that this court already did set a line in the Abieli case.
The other, there's more mega point that he makes, that the legislature did not intend, through the necessary and convenient clause, to allow an IDA to insulate itself when it comes to a state grant, right, the state's money.
Well, the state wanted us to do this. The state was asked us to take the grant.
Not the
IDA,
subsidiary, right?
Well,
when you sought out the
IDA,
grant, did you say to the government, oh, and we're going to create the subsidiary?
Yes. As a matter of fact, initially we wanted to do it as an LLC. They said we're not going to do it to an LLC, do it as an LDC, so we created the LDC. We wouldn't be accepting that grant if we couldn't create a subsidiary, and the state's purpose would be frustrated.
Then why didn't you end up accepting the grant?
Because the state and the business that were pursuing that grant ended up not coming to fruition. But back to your question on where the line is. This court set the line in Abieli. It has to be necessary or convenient to the exercise of another express power, and you can't do anything outside of the legislatively granted sphere. So, for example, in that case, where you had an administrative agency taking on a quasi-judicial role, which is way out of the realm of what they're allowed to do under any stretch of the imagination, that's the line. And here, properly structuring a transaction is well within the IDA's authority.
Thank you,
Thank
counsel.
you.